procedure govern eminent domain proceedings. The Florida statutes tell us that. Florida's Blue Book, it's the eminent domain Bible, so we say. It's the book from which all standard eminent domain jury instructions are taken. That directs that we have to plead enhancement because it drastically changes the nature of a case. And it does, it absolutely injects a new matter. You're not just simply saying there are no damages. In this case specifically, you're not just saying there are no damages to the southern remainder of the property. You're saying not only do we deny your damages on the south, we think your property up north has been enhanced. That injects a new matter. Under the Moore Meats versus Strawn Florida Supreme Court case, I think that that's necessarily a new matter. You have to plead.
But let me ask you this. Let's just assume that they were somehow required to plead it.
Sure.
If the trial judge had sustained your objection on the pleading issue, wouldn't they have been able to argue that they're allowed to amend because you're not prejudiced by the omission in the pleading? And how were you prejudiced if that's the test?
Well, for one thing, we were prejudiced because, and I'm not divulging anything because this was the subject of another appeal before this court, there was an outstanding offer of judgment. So on remand, our table was set. I mean, the county knew we couldn't hire a new team of experts. Nobody would come in on board with an OJ outstanding. But they wanted to change their whole theory of the case.
I mean, your expert was prepared to give testimony about us and quantify the special benefit, right?
Yes.
And did, right?
Well, yeah, we thought there was zero special benefit.
Well, but I mean, your expert was prepared on that issue. So, I mean, you didn't put all your eggs in one basket, in other words, and hang your hat on the pleading issue. You all were prepared to present evidence and to meet their evidence as it relates to special benefits. So if they'd have said, Judge, they're right, we didn't plead it, but they're not prejudiced because everybody's ready to go on this issue, so we'd like permission to amend, wouldn't it have been the trial judge's responsibility at that point, absent a finding of prejudice, to grant the motion for leave to amend?
You know, maybe, but they didn't even ask, or they didn't even try to set the table correctly.
They didn't ask because the judge, ruled in their favor and said it didn't need to be pled.
Well, but they, even on remand, they never once sought, in 7 years, they never sought to plead special benefits. But I think the panel hit on something else. There was more fundamental problems with the actual testimony. Their appraiser admittedly could not differentiate between special and general benefits. I mean, he said it, he was very candid, he was very honest. At the transcript, page 751, page 757, even during his deposition, he said, look, I concluded to an enhancement number. Here is my number. But I cannot or will not tell you which portion of that number, this bundle, is special and which is general. He couldn't do that, and he told us very candidly he couldn't do that. That means necessarily some amount of general benefits was improperly offset against our client's severance damages.
But ultimately, did he give the 1.9 figure?
He gave the 1.9 figure, but that wasn't, that was not, his testimony was not that the one of my 3.6 million, 1.9 is special. That's not what the testimony was. The only testimony at trial about special benefits whatsoever was the $1.9 million number. Now,
right, I mean, he ultimately gave a $1.9 million figure for special benefit, correct?
Well, for benefit, but he said during trial about that number, about the 1.9 million, he said, I'm finding special benefits. Whether you want to qualify them as special or general, I'm not going to do that. I'm just going to say what the benefits are. Transcript 757, as far as the special benefits calculation, I left that blank because I didn't want to classify them as special or general benefits because that's a legal determination. It's the same thing he told us in his deposition. Like, he just came up with a number, and he did not feel comfortable breaking out what portion was general and what portion was special. But that testimony, look, we think they snuck one past the goalie, frankly. We think they didn't plead it, and they were supposed to plead it, and they couldn't, their own appraiser couldn't differentiate between special and general, but they got that testimony in. And surely, I think Judge Egan was within his discretion to hold the county to what they told the jury, to what its expert and its attorney told the jury again and again was their number on special benefit, which was 1.979. You know, I think they need to honor that. And look, this is by no means a slam dunk for us. In fact, Judge Egan remarked during the post-closing argument, or excuse me, the post-trial argument, that he thought we'd be the ones appealing because we wanted that whole special benefit number stricken. But, you know, enough is enough. Our owners want to be done. You know, we claimed severance damages of $4 million. The first jury gave us $2 million. This one gave us $3 million if you ignore the set-off, the improper set-off. And as a result of Judge Egan's additure, we're going to net about a little over $1 million. That's a far cry from what the juries have given us and what we wanted. But look, you know, it's been 7 years, and we would like to be done. Obviously, our preference is to have that entire special benefit stricken, but I do strongly believe that in the scheme of things, what Judge Egan did was ultimately fair and logical and based in the record. So if this court is not willing to strike on the basis of failure to plead, which I think you can do under the Udell versus Udell case, the Muchnick case, the Arkey case, then we would ask for Judge Egan's opinion to be summarily affirmed. And then, of course, our third option would be a new trial with an instruction that they don't get to amend their pleadings after this many years of litigation and try to do the special benefit defense this late in the game. And actually, the Supreme Court Arkey case would forbid them, I think, from doing that if this panel agrees that you do have to plead special benefits in eminent domain cases. And, you know, on that front, you know, the Blue Book says you should do it because it injects a new matter, but also the majority of states in this union require special benefits to be pled in eminent domain cases. And the county only cited one Oregon case that stood for the opposite proposition. But what's funny about Oregon is you never have to plead set off in Oregon anyway. But we were, in full disclosure to this court, we looked at that issue, and I think when we wrote the briefs, it was a 4-3 majority in favor of having to plead special benefits. In preparation for the oral argument, I found it 6-4 at this point. So I think Florida, being so protective of private property rights, would go with the majority and require that to be pled, because it absolutely injects a new matter. There's just no denying that. Do you guys have any other questions?
Not now.
Okay.
Okay, thank you. All right, I think, just a second, Counsel, let me try to get the clock right, because it has completely reset to the power failure. You had about 3 minutes and 50 seconds left. So I'm going to give you 3:59. Go ahead, sir.
Thank you, Judge. May it please the court. The ITT case held that Section 768.043 only authorizes conditional additor awards in tort and contract actions arising out of the operation of a motor vehicle. There is no eminent domain statute that authorizes the trial court's additor of $837,471 in this case. And in fact, the Florida Supreme Court has determined that a trial judge has no authority in an eminent domain case to order an additor to increase the jury's verdict. That's the Bennett case.
Yeah, but I mean, that was before the statute, so really it still comes down to whether the statute authorizes additor, right?
Yes, Your Honor, although the Cox case, which was a third DCA case, as well as going back to the Denmark case, which was a fourth DCA case, and the Denmark case was after the statute, and the Denmark case, and as well as the Cox case, as I said, both indicate that additors are unauthorized in eminent domain actions. With respect to the failure to plead enhancement value or special benefits, it's not required that it be pled. And I get there from Florida statute section 73.701, I believe it is, and also from Florida Rules of Civil Procedure 1.100E, as well as, 1.110 subparagraph E, as well as 1.100. 1.100E states that averments in a pleading to which no responsive pleading are required are deemed denied. It's only in the situation where you seek to avoid the affirmative defense where you have to plead. And this was dealt with actually in one of the cases that the Owners Council cites, and that's the Moore Meats case. That was a Florida Supreme Court case. In that case, Mr. Trawick actually weighs in or cites to Trawick Florida Practice and Procedure are made. And basically what Mr. Trawick comes down to, and that case comes down to, is that only when the pleader wishes to raise a new matter in avoidance is a reply required. But here, enhancement value and special benefits are not an element of damages. They're a factor, an ingredient, a component, if you will, in the final calculation of severance damages. They are not a separate element of damages to be awarded. And similarities are found with respect to the cost to cure. The cost to cure in eminent domain cases is not required to be pled either. And also with respect to reasonable probability of some type of zoning variance or waiver, the same thing. But more importantly, what I want to deal with also...
No, you're not going to deal with anything else. You're over time,
Okay,
sir.
thank you, Your Honor.
All right, thank you. The court will be in recess. Thank you for your arguments.